understand its implications, its challenges, and its potential. The law, that's the Act, introduces a comprehensive framework for imposing rates on the land and the buildings by county governments and on all valuation or rateable property with the use of technology to ensure accuracy and efficiency. So this is something almost new for all of us. The legislation will certainly have far-reaching implications in the land sector, and there is need, therefore, to create awareness for all of us, those who are landowners, potential landowners, and to understand the implication in the land sector. So there is need for us to discuss, and I hope all of you will be engaging in this discussion as we move forward. At the heart of this forum, which we are having, is the need to share knowledge, to identify the opportunities which are available, and to collaborate toward finding solutions that will allow us to adapt and improve the implementation of this new law. It is not just about understanding the legal framework, but also how it touches the lives of ordinary Kenyans and also businesses and the communities across the country. As we delve into today's discussion, we are very privileged to have a number of experts. I hope they will come on time, and the policymakers among us, including stakeholders, who will provide us with very invaluable insights into how this new act is reshaping the way properties are rated and taxed, as well as the broader impact on economic growth, county government financing, and on social equity. I would encourage each of you to engage in the discussion today. Ask all the questions you need to ask so that you can get the answers, and share your perspectives with the authorities. Working together, we can build a more comprehensive understanding of the National Rating Act and ensure that it is there to serve intended purposes while addressing the needs and concerns of all of us and all those who are involved. In concluding the remarks, I wish to delve into a different topic, as to inform you that our general meeting, as the Friday, 28th March 2025, from 9 a.m. to 11 a.m. at Ngong Hills Hotel on Ngong Road. We remind the members who are yet to renew their subscription to those who are ahead of the AGM in order to enable them to fully participate in the meeting and also to participate in decision making. Please diarize the date for the meeting and join us as we reflect on last year's milestones and share our insights into the plans ahead of the organization. I hope to see all of you there for this particular meeting. I thank you once again for your patience and for being here. And I look forward to the discussions we are going to have. Hope it will be thought-provoking, ask all the questions, and let today's forum being meaningful and productive. So all of you welcome, and asanteni sana.
is a forum for all of us. So you know, say nobody has a property of information knowledge. Each other, and we also get to know each other. There's also make and see how to work together.
One, two. Ladies and gentlemen, one, two, mic. Seems they're not all working, but it's okay. We'll continue. Good morning. I'm happy to be here this morning and to join all of you for today's forum. Thank you, Henry and Mr. Nyaga and the entire Kara team for organizing today's forum. It is good to be back. As they have already mentioned, our partnership on these forums has existed for so many years. And so it's wonderful to be back with these forums. For the gathering the relevant dialogue associations and to Kenyans at large. My name is Robertson Kafusha, and I work for an organization called the Hans Seidel Foundation. As has been mentioned by Mr. Nyaga and Henry as well, we have partnered with Kara for there about 20 years now, which is quite a long time of consistency in partnership and impact around providing a platform for citizens to have dialogue with relevant stakeholders. Over the years, this platform has provided citizens and in Nairobi and other counties, as was mentioned, an opportunity to engage with a variety of stakeholders to exchange views on pertinent issues such as today's topic. The Hans Seidel Foundation is a German political foundation. Our work in Kenya through local partners focuses on the areas of democracy and governance, gender, and climate change. Today's topic is key. When I saw the notification for the event, I was like, wow, what is the National Rating Act? You know, those subjects that never come to mind. But I believe that it is an issue that is of critical importance to different stakeholders, particularly those who are in the real estate. And for the purposes of this platform, which is to provide that dialogue platform between citizens or interested stakeholders with government or relevant public institutions to gain information and to give their input and to learn. So we hope again that we have been able to provide this kind of platform to dialogue over this key topic, and I believe that the speakers invited are qualified and have the relevant information to give it to you, and that you will also have the opportunity to ask questions and to give further input to make it successful and to know how it applies. As it was stated in the invitation, the aim is to enable property owners and other interested persons to understand the implication and the role they are expected to play in order to be compliant with the law. And I therefore hope that in the course of today's session, we will be able to achieve exactly that, if not more. So I wish you all a wonderful dialogue platform, And even before I sit, just to convey the apologies of our resident representative, Mr. Daniel Zaibaling, whose name appears in the program, was supposed to be here, but a matter arose that he needed to attend to. So I would like to convey his greetings and apologies. So I wish you a good session and a wonderful day. Thank you so much.
Thank you so much, Robertson, for those remarks, and the greetings from Daniel, well received, and apology also well noted. So, ladies and gentlemen, we now want to get into the conversations around the National Rating Act, which is our main topic today. And like I mentioned earlier, we have put together a team of speakers who we believe can be able to give us more insight on this legislation and also answer some of the questions that we have, because I know we do have questions, we need clarification, and we just want to know what this means and the implication that it has. And so to enable us to get to that understanding, let me now invite our speakers to just step forward and take the seats in front here. Starting with Mr. Michael Okello, who, as I mentioned earlier, is an advocate of the High Court and also a valuer by training. So he's both a lawyer and also a valuer. And he had an opportunity to interact with this legislation during its preparation. And even now, he has quite a number of insight on what it's all about. We also have Mr. Herbert Were, who is from the Ministry of Lands. That is the anchor ministry for this particular legislation. So Mr. Were can also join us in front. And of course, we are looking forward to engaging you in that regard. I don't know if Mr. Jacob Keeper is here. He had told me that he'll be in a short while. Jacob, I have not met you, but it seems he's not yet here. But I know he's on the way from the National Land Commission. As you know, the commission is also directly responsible on issues about land, including the topic we're talking about today. So they'll be able to engage us. Is that Jacob? Yeah, I was just looking for you and you walked in. So you can join us here. So Jacob Keeper is a principal valuer from the National Land Commission, and they were part of the team or the people who were behind the formulation of this legislation. And I believe also they are going to take a very active role in its implementation. So, ladies and gentlemen, this is the team that is going to give us insights into this legislation. And again, I have to repeat that they don't have the monopoly of all the information. We are also going to share what we know. We are going to ask questions that we need to ask and just engage so that we are at a place where we can be able to benefit from this conversation. I can see you all have laptops, meaning you have something to present. Maybe we'll ask the hotel to make that arrangement. I don't know if they did, but we can check with them so that you can be able to project what you have. So as we do that, then I'll request Michael just to come forward, and you can start with the preliminary conversation as we look at the issue of projection. Karibu, Michael.
Thank you, sir. I humbly honor the presence of our leaders from CARA, my fellow presenters, and the entire team who are our audience today. As you've heard, my name is Michael Okello. I'm an advocate of the High Court, and I have a multidisciplinary background in land economics and sustainability studies at the graduate school level from the University of Nairobi. My interest in this country is moved by the love and really passion for policy, policy persuasion, and public policy that touches on issues of sustainability, governance, and property as widely as it is defined in the Constitution, where we know the property entails land, and the definition of land is also wide, includes the solium or the physical aspect plus the interests that run with them. Property also includes intangible assets like IP and the rest. So my interest today is confirmed by this invitation, and as we unpack the National Rating Act, I wanted just to arrive at the background and the foundational aspects. And the Constitution of Kenya, especially Article 1 and 2, they tend to reinforce where we are coming from. And in Article 1 is where we see now the delegated sovereignty of the people that is reserved within the three arms of government. And of our focus today is the county government, where we have the county assemblies, and also the executive, where we have the CECM. That is the county executive member. In this case, in our presentation, we'll be focusing on the one in charge of finance. Of course, working in collaboration with the county assembly and the country and the stakeholders. So, as I arrive on the foundational background, then Article 209 of the Constitution designates revenue sources, including the ones for the county government, and as I've said, also Article 1.3 and Article 185 vests the county legislative authority within the county assemblies, which must and will always have to work together with the CEC member responsible for finance. Article 94 gives us reinforcement of the legislative role of the county assemblies, and it provides that any legislation, whether by the national government at the parliament level, where we have the Senate and the National Assembly, or at the county assembly level, those legislations that are made, they must be very specific. They cannot be arbitrary. They'll need to tell us the what, the how, the why, and the when. And so in simple terms, they have to define the purpose of those legislations, their objectives, their limits, their scopes, and their principles. And as we see the National Rating Act, it is an act of parliament that provides a comprehensive framework for imposition of rates on land and building. So there are two contexts there which we'll discuss, but the county government. Now that one is the main stakeholder, the implementing agency in this case. And also they provide for appointment and powers of the valuers. In this case now we are dealing with the chief government valuer as well as private valuers. And we'll see the advantage of this because of the nature of the work that is entailed and the short timelines that we need to discuss as one of the challenges. Another important aspect is the establishment and the function of the tribunal and the appellate processes that go up to the ELC. And we know the jurisdiction of Environment and Land Court is very wide today, and with the reforms in the judiciary, we are well to go. And maybe another thing that I might need to mention is that Article 209 of the Constitution of Kenya 2010 empowers the counties, where appropriate, to impose property rates and other taxes such as entertainment taxes and authorized taxes. So when we talk about authorized taxes, it means there is a force of law. It is not arbitrary. And finally, Article 207 of the Constitution of Kenya provides that each county has a revenue fund, and we've seen the transformation in the opportunities that the county governments have. But they need to guide Kenyans and of course the stakeholders so that whatever is paid is fair, and we will see how rates are linked to taxes. I wouldn't want to go so much. I know you will have these slides because it's my joy that Kenyans and my fellow scholars read what I've written so that we engage. So the first item there, I'm saying that the operative law, which is the lex specialis, that the main law that guides rating in Kenya today is the National Rating Act. And if we read the Interpretation and General Provisions Act, Cap 2, it defines what repeal is and what this law has done to the Rating Act and Valuation for Rating Act. And Mr. Were here, who is my senior in the Institution of Surveyors of Kenya, will agree with me that the Rating Act and Valuation for Rating Act has been there since we were born. I was born and I found it. And it's good during my life, some changes and reforms have really been considered to cure the processes. But what I'm saying here is that the effect of this act, if you read section 57, it ipso facto repeals the Rating Act and Valuation for Rating Act. And what repeal means then is to rescind, revoke, cancel, or replace. So in other words, in this transitionary moment, Valuation for Rating Act and Rating Act are not in force. And what then does that mean? In this transitional period, if there's any valuation role or supplementary valuation role that was in effect before and even currently, it will have operative force because it is authorized. Another thing that we note is that if the roles do not confirm, then there's a word used here, they need to be modified. They can be modified through legislative enactments that are mentioned under the last part of the Act, which provides that the counties can now legislate and enact laws to enable the processes and implementation of rating. But while that is done, then the same Act also provides that those county legislations should differ and refer to the National Act, which is the National Rating Act, as well as the attendant regulations that will come. Some of which regulations will come from the operations of the Cabinet Secretary through the Ministry of Land, as well as through National Land Commission, especially those ones that touch on public land. So I will want us to move fast, but maybe from the oversight, the implications that this Act poses on us is that one, unlike earlier acts which provided for renewal of roles after every 10 years, of course with provisions of preparations of supplementary roles, a supplementary role is one that comes in the interim. It is an intervening circumstance, kind of a cure, especially due to changes that we'll explain. But in normal kind of scenario, we should always have valuation role through the due process, then it is renewed after a period. Initially it was 10 years, today it shall be 5 years. But the law has also allowed and provided for flexibility. The CEC member in charge of finance in the county, through liaison with the county assembly, the county can give approval so that the period be extended to 2 years. So we can confidently say that a valuation role can last 7 years. Then the law also extends the definition and the operative use of the word rateable owner. Previously, you'll think that the person who owns it and it's registered in his name, that property or land, he is the sole rateable owner. Today, it's expanded with the coming of the Sectional Properties Act and the regulations. Within a title, you can find a set of units. And in the title documents, then they'll refer them something like Unit A on Block B, and one of the 100th part of the common area. So in that kind of scenario, so you realize each person then will be apportioned the rate that he should or she should pay. And there's an extended discretion and jurisdiction of key institutions and offices that never existed before. And that's why we say this legislation is timely and it comes with reforms. The chief government valuer is in the heart of this process, and also the National Land Commission is in the heart of this process. And of course, again, the CEC in charge of finance in the counties is in the heart of this process. And before we forget it, the rateable owner, and for that matter, the CARA groups of the constituents, they are key stakeholders and partners that can't be gainsaid. And that is why in public participation, That is the best place where it starts. I wouldn't want us to define rates, but as lawyers, we always refer to Black's Law Dictionary to guide us. And it says that rate is a proportion, a relative value. So that is why in our valuation, we say that we will first do the valuation, then we get a proportion of that valuation, and that is what we call rate. And there are processes of getting that proportion of that value before we get the proportion of it. And of course now when we deal with the county governments and what used to be called local authorities, then we do the assessment of the same based on the methodologies and approaches that valuers will always properly explain. So Ghana has done a lot on legal writing, and is somebody I love so much as a law student. And the dictionary that comes here, there's an aspect of tax that he brings in which may make us consider rates as a very special type of tax. Because we always say tax is a statutory, compulsory payment made to an authority within stipulated timelines based on law, and it is unrequited. But when you check about the rates that we pay, the rates that we pay are exactions, yes, but they are not unrequited. Because in the end of the day, we expect to get services: water, security, local transport, based on the 4th schedule of the Constitution. So Ghana explains in his edition of Black Dictionary what is the nature of tax. And that is why then, when you talk about rate, as it is defined, they call it property rate. It is a form of tax. Now, the main concept that I'll explain here, then the rest we can discuss in the discussions. When we talk about rateable value, is that value that we will get the proportion of. In the current act, the rateable value is classified under 4 categories, and we will see them. One of them is an improved site, which other counties like Mombasa would call site value. But generally, we know it's an improved site. That is a vacant land. And we can also have area rate. Mr. Were knows very well how valuation indexes have been done across the country. So where a value is assigned to a particular area, and you work a percentage of it to get the rate, then it becomes an area rate. Then you can graduate it. Maybe you say the first 10 million of value, we award 10%. The residue, we award 1%. That is graduation. You can differentiate it. You can say maybe for residential property, 2% of the value. For commercial property, 3% of the value. That one is differentiation, in this case based on categories. Okay? There are key concepts that this act has brought that gives Kenyans an avenue of reprieve, if you can call it. One of them is remission. Remission has been confused with exemption. I will not mention waivers because Honorable Sakaja has always given us waivers. A waiver is a relief that you don't pay penalties and interest earned thereupon. Just pay what you needed to pay. Time has lapsed, but just pay that. That's a waiver. But when we talk about remission, it modifies the liability that you have. In the end of the day, you might pay less. It lessens the burden. They say, okay, your penalty was to be 1%. You'll give us 0.02. They might consider certain circumstances. You've been a timely, reliable, rateable owner, and maybe circumstances that you brought occasion to that. This is the slide I wanted to show. And if I show this, I can sit and I'll be okay. So when you want to approach rating based on the reading of the act, and with my background in valuation, I'll be glad to explain this. The purpose of valuation that we are dealing with in the National Rating Act is called valuation for rating. So that is the purpose. Based on the questions that I've already received, as we move, they shall be answered. Rateable property is that particular property, and it is identified through parcel numbers or titles. Mostly, we expect them to be leasehold if they are agricultural. Freehold is exempted. Category of the user under Section 12 of this Act. Is it residential? Is it agricultural? like Mombasa have added more categories. Is it for non-renewable energy generation, in which case the struck is high, like prohibitive, because of the climate change issues we've seen here. Now, after that, then, you assess the rateable value, which I've said can take these forms. It could be annual rental value. So they'll say, instead of calculating it based on property value, we will calculate it based on the annual rental value. In the Kenya valuation standards, which has been referred in the Act as local standards, Kenya adopted its Kenya National Valuation Standards, which we call Blue Book, and it provides that when we assess rent, then the approaches that the valuers use include the sales approaches and comparable market approaches on the basis of market rent. Then there's area rating, which I explained. You've gotten the valuation in form of indices of different areas based on their distinctive features, and you assign value for these areas. On that value now is when you will occasion the percentage to get the rate. Another category of rateable value is an improved site value. This is value as vacant. In our valuations report, we used to call them on vacant possession. So you want to know there's a premise here, yes, but what is the value of the land itself? So that is an improved site value. Many authorities call them site value. Whenever you see site value is an improved site value, then the combination of these approaches comes in, like in the case we are dealing with. We are talking about sectional properties, and there are also shared portions of common areas. So in this case, you'll find as much as you want to assess or value rate for the unit, which is an improvement, you also need to assess and apportion rate for the land portion of it. So then the basis of value should not be confused by the method of valuation. The basis is what informs the approach that you'll use and the data that you use. In this case, it is market value, and the track is the percentage. So, example 2, if the rateable property was that parcel and category is industrial, then the site value could be based on improved site value. Then maybe you assign 14% to it, and maybe you do the calculations and you'll find it. So if you've delayed in payment, then you can face issues like penalties. You could request for waivers, and they might adjust them. In the adjustment, they can give you remissions, they could give you discounts, and all that. So maybe I go to the process. I hope this will be shared. Just to save time. So the Act actually talks about the due process. And maybe for our interest here will be to consider the timelines, where our responsibilities are intended, and also the key aspects that need us to participate in as CARA, or Association of Resident Associations. And the first thing is that the valuation shall be undertaken for rating purposes, as we've talked about it. And the CECM is in charge of setting the struck. Struck is just that percentage to get the proportion. And under Section 14. And for me, this one as a policy person and a legal person interested in public policy, I will be concerned about the capacity and support that CECM needs. And especially from the national government, the Chief Government Valuer's Office, and of course within the set of professionals within the county. So once valuation report is done, the law provides on the contents of valuation. But in this case, we know that the valuation role should identify the property, describe it in terms of category, the rateable value that was considered. Was it annual rental value, or was it the site value, or was it the area value based on the indices? And then they calculate that based on the struck. They provide the physical information regarding the property and all that. So and CC member, then we will consider it and make copies and avail it to the public for consideration, and also to the county government, and also a draft to the Chief Government Valuer. So when the Chief Government Valuer peruses this report, because he's the principal advisor to the counties on rating matters, he will provide this report, an independent report if you like it. Then, based on this report, and the published draft, there will be what we call public participation. And I think this is where organizations and societies, including CARA, will really find it very useful. And because this is a transitional period, the kind of questions that were raised, the kind of issues that need to be addressed, they could be captured within the county legislation, because each county will enact its own legislation, which will identify the STRAC, which will identify the basis of valuation, and this particular county in its legislation will tell us which of the 4 categories of rateable value they'll use. Maybe there's a county that will use area rate. Like I've seen Murang'a County is using area rate. They say for us, the rate you pay is maybe X shillings per acre. So if your parcel is 1 acre, you know what you will pay. Counties like Mombasa are using site value. So they tell you this is the unimproved site value, and we award maybe 14% for this type of land user, and they tell you to pay. And within the legislation, they also must state the interests earned at what rate, mostly at CBK rates. That is what the Act has really reiterated on. So once that is done, and your comments, your views have been found, then this report with the comments. And this is where, again, diligence from this association and Kenyans will be very important, so that they follow to the letter that their comments and responses have been considered in the report. Because upon submission to the county assembly, it will resolve. But if your comments were so compelling, the county assembly may not approve it. They will reject it and maybe revert it back maybe to the valuers for consideration and to be reworked on. I preempt situations that may arise, especially on the STRAC. I saw one where STRAC has been assigned 35% for a unique type of user. You see, that one might raise issues. And last year, Mombasa County set a rental STRAC that for 2024 and 2023, they were a bit varying. So somebody will ask, why is it increased by 1% today? And those kind of discussions. So if you find that maybe the STRAC were high, or maybe the rateable value that was used wasn't appropriate, then you'll say, well, instead of using a new site value, why don't you use the annual rental value then? Then they'll say, okay, for annual rental value, we'll assign 2%, or for unused site, unimproved site value, we'll assign 20%. So once that is done, then there'll be publication. We are assuming the county has approved it, then it is published. Now, this is again where Kenyans and stakeholders will also need to be very keen, because here is where you can identify errors, which I've talked about in the slides. You can identify inconsistencies in terms of entries, descriptions of rateable owners. Maybe your name is put as the rateable owner as well as the owner of the site, and many other kind of things. Maybe the property is under, it's owned by a company or entity going through liquidation process, or the owner of the property is deceased and is a succession matter. The description of the rateable owner should be changed to include maybe the administrator or public trustee in that matter. So those ones will be very important to come at the publication level, where the comments will be gathered. Now, should there be issues, then you'll raise objections under section 36, and the timelines within 45 days. So the process of raising objection is more keen like filing pleadings in the courts. You have to give notice for non-refundable fees of 10,000 shillings. Sometimes you may not have the opportunity to give the intention, but you file the objection straight away. The CEC in charge of finance might consider such scenarios. And where conflicts arise in the nature of objections, then the CEC will constitute the county valuation board. And the county valuation board that is constituted in the counties is a very key body here. And the representation, their capacity, and their effectiveness is very key, because it affects the resolutions and remedies that they'll offer. But if it goes beyond the CVBs, that is the county valuation board, then it will go to the National Rating Tribunal. Now, this one is the overarching arm at the national level, with representation from key professionals, including lawyers, valuers, land specialists. So we are sure, and we are empowered that this team will be very, very well equipped to address those issues. And the law also allows them to add more members as ad hoc members. Should the appeals fail to resolve the issues, and maybe the conflict is between rateable owner and the imposing agency, then ELC. But here I'm raising a question. I've tried to check and ferret within the act. I've not seen ADR mentioned clearly. But what is coming up is that there's a provision for collaboration between the National Land Commission, the Chief Government Valuer, the stakeholders themselves, and the Cabinet Secretary, and especially with regard to the regulations. So the stakeholders will also need to be very careful during the processes of legislation when the CS in charge of these matters in rating actually publishes the regulations, because the regulations that the CS will publish, what we call promulgation, it is the same ones that the county governments will give deference to. Just the way the same legislation will give deference to the Constitution. So at the point of what we call the statutory instruments, the regulations that come through the CS, the wide process of public participation is encompassed there. We need to participate in that, because from those instruments is where now the county governments will legislate the county legislations that sets the rates, the bases, and the processes of rating. Now, I'll just mention the reprieves that we have in case things go wrong. There's provision to prepare supplementary valuation roles, maybe to make alterations due to errors and omissions and changes in the particular land. I might own 10 acres today, and I sell a portion to Mr. Henry. The rateable amounts will change. Percentage might remain the same, but the amount will change because the size has reduced. So those ones can be captured through supplementary roles, so that you are not charged in the subsequent year the same rate that you are charged the same year. So there will be some credits and additions. There could be recategorization. There could be change of user from residential to commercial. And we see it very rife today. If you drive through along Gong Road, you will see changes that are happening around Kilimani. What used to be residential, some changing to office spaces. You know, you move along Westlands and City Park areas, you see the changes. Sectional properties from what used to be townhouses and somebody on his own site. So those ones will need the owners or rateable owners or their representatives in organizations like CARA to really stamp their feet and raise these issues so that their members shall pay what is legally authorized. So any change that might materially affect the value of land, Mr. Were will confirm in land economics and of course physical planning, there are things that will have the diminutive effect on the land value. One of them we call betterment. If there's improvement in the general area, in some counties they even charge betterment tax because the place has really changed. But the opposite is also common. You know, some of us know what happened in Mombasa in some area where pollution really affected things. The value of land in that place can materially fall. And in that case then, there will be need for re-evaluation. In other words, when we have supplementary valuation role, there's some sort of revaluation processes that happen. To err is human, and these are reprieve that you have also. The Act provides for corrections to be made based on alterations arising from errors and omissions in recording, in entries and descriptions of the property. If your property is described as commercial when it's residential, then you know you stand to suffer because the rates will spike. You can also benefit from exemptions. So, and when Henry was asking me to highlight key issues and what actually the rateable owners should consider and CARA for this matter, exemptions, the Act has come with very key and unique exemptions. And one of them is that land used exclusively for public purpose is exempted. So when you want to know what public purpose is, and I've presented a lot in ISK, that's the Institution of Surveyors of Kenya on compulsory acquisition, and they describe why it is done. And the main reason is always called to effect public purpose. But public purpose is quite general. The narrow definition of public purpose is very strict. It is acquired by the government for a public utility that is utilized by the public. So it is requited. But then the broader view of public use is one that is done just for public purpose. Whether it's done by a private entity so long as it was acquired on their behalf by government through National Land Commission maybe, and it is given to private investor maybe to build social housing, that one will be public purpose. So how you define public purpose is a big issue here. Land that is used for public purposes, those that are listed under Section 38 of this Act, religious, cemetery, crematoria, but you've seen what I mentioned earlier. If these kind of properties or users are attached to some profit generating, the component of profit generating will be accustomed to rating. And there's also a question that was raised, whether agricultural land that is not freehold is subjected to rating. The answer is yes. Why? Because they have said what is exclusively exempted from rating is what will not be rateable property. In other words, in law we say what is not exempted is subjected to rating. So remission I've explained. What we need to consider here is the timelines that you have to actually apply for remission and also seek exemptions, and the county government. And in fact, during the legislation process at the county level, the members in their respective areas should be very keen so that they make sure provisions and processes of seeking remission exemptions are included in that act, so that you put provisions such as the county government might allow exemption, remission, blah, 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 on circumstances such as A, B, C, D. Like COVID time scenario, you know, force majeure issues of the kind. And then they might do that by considering to adjust the percentages, that is the struck. They might consider to lower the levels of interest and penalties, or actually waive them. And I've seen Honorable Sakaja waive them, and also in the county of Mombasa, I've also noted at instances. You could also be given discount, a reduction in what you should pay. So as I almost close, I know my slides were long. I'm just trying to pass through them. Mr. Andy, allow me just a few more minutes, like 2. Okay. So our responsibility, rateable owners is a wide concept. As you see in the Act, a rateable owner is not only the owner of the property. It includes the trustees, where we don't have trustees or administrators, or what we call administratrix and administrators. The public trustee could always take over these matters. When I was doing my pupillage at the State Law Office, that is the Office of Attorney General, we would help those people who can't actually confer the properties to them from their deceased relatives, and the public trustee will take over this matter through various processes. So a public trustee in the name of government at the office of the AG can actually be a rateable owner. So in their responsibility, they make sure that this property that they are realizing, the rates are duly paid and captured under the expenses, or the persons that are dealing with these properties have actually paid the rates. If they exert the money and utilize them, maybe what we call maybe a personal representative on behalf of the deceased estate has utilized this money, what we call now, you know, intermeddling, it will be a legal issue. So we make sure that they actually make sure that all these are paid. A rateable owner could be a tenant of large scale or long-term lease, and in our laws, our Land Act and Land Registration Act has defined what a long-term lease is, in the nature of which must be registered and titles issued. One example is the sectional properties. So the owners of those long-term leases in the name of sectional properties will pay rates. So in areas where we reside, in the associations where we stay, if these are blocks and there are courts where we have apartments, the Sectional Property Act provides for corporations and bylaws. You know, the bylaws will be such that each person is assigned his rate, and they make sure there is order for common areas. So if we had 10 units and you have unit A as your house, then we say Michael Okello, the owner of unit A, and 1/10 of common area in rates should be paid. So in that case, it will touch the property, which is the physical artifact, and the land. So another responsibility is we consider exemptions and utilize them, especially in this transitional time. If you own a freehold land, which was subjected to rating, if at all it was, then you should seek exemption. If there's a public user property that was subjected to rating for some reasons, the law provides that the CS and also in liaison with the CECM in a particular county can negotiate and come up with regulations that can actually guide the processes of rating, what can be exempted, what should not be exempted, and what will really be paid. You might find that in such scenarios, the rate that is assigned is lesser than the others. And that's when we talk about differentiated approach in rating. Another aspect we can consider is to understand the valuation roles. Peruse them. Organize sessions like this when the roles are published and people discuss them and people raise issues so that when we go to the public participation, we are given a wider period of time to respond and give comments. We can meet, we can discuss them and submit our comments. And also we should know that the law provides for interventions, for exemptions, for discounts, for postponements, and of course for dispute resolution mechanisms. So areas for reform for me, we need to justify the amounts that are set in these acts. Why do we say that in compulsory acquisition there's 15% for damages? Why do we say that for stamp duty for agricultural land is 2% and urban land is 4%? Where did 4% come from? When the county government of X county says that the struck for industrial we charge 30% and Nairobi maybe charge 25%, what is the rationale? You see? What if your property, you also generate renewable energy and you supply to a school, which is a public entity? Should you be charged the same rate? So those are kind of arguments and questions you can raise at the point of public participation, because that is a reform issue. The county governments will not operate in isolation. They need an authorizing law, which they will legislate. So another opportunity that I found very, very, scanty in the act is the aspects of ADR. ADR is everywhere. We expect and assume that ELC will consider them. We talk of overriding, the oxygen principle, overriding interest of the courts. Of course, that one they will invoke. But what about the county valuation boards? Did we allow for some ADR processes therein? You can fix that in the county legislation, because that one actually differs to the constitution itself. And what are the channels? The best example I can give, when I was doing a paper on the ADR in tax matters, you are told to first pay based on the demand and plead your case. And they provide for alternative dispute resolution mechanisms through the frameworks of Kenya Revenue Authority. Could we have such thing in our counties? Is something to think about. Then the need of counties to be equipped and work in liaison with the chief government valuers. Where are the county valuers? What is their place in this? And the residents association, do they get due information? As I finish as a valuer, when I talk about compulsory acquisition, which I know is a very highly debated and contested issue, the landowners will always ask you, Okello, how did you arrive at my valuation and compensation to be 10 million? Tell me. As a valuer and as a lawyer for that matter, I should be happy to explain. I am guided by Kenya Valuation Standards. Kenya Valuation Standard refers to international valuation standards and the Constitution, the Article 10 principles. So I should be ready to explain. Public participation, tell them. Disclosure, transparency. Our basis for valuation for your property was market value. We referred to assessment of just compensation from National Land Commission. We added these other additions because the rules provide, and now this is your value. Your property was worth this much. This is the valuation report. We've summed all of them. This is your word. And you will say, Okello, Kongoi missing. So I'm finishing there, Mr. Henry, and I know we can have questions. I was so passionate about this presentation. Forgive me for my long slides, but I know when you read them, some questions and the discussions will arise. Thank you once again, and God bless.
Wow. Thank you so much. We certainly will share these slides because I think they're very useful. Are they? Are we learning something? I'm personally learning a lot. I think it's taken us through a very comprehensive presentation, touching on various aspects of this particular law. And I want to believe that our next speakers might. and also how you are
that comes and is not solved at the county level is supposed to be transferred to the chief valuer, government valuer, and the chief valuer now is a tribunal and renewal formed, and any objection that was not solved there is supposed to be solved at that particular level. And I'm sure it will also be formed or something like that. The function that always do on a daily basis, we are managers of public lands. We are managers of public lands. The commission also make, or rather, in consultation with the Ministry of Lands, recommend national land policy. The commission also assesses anything that has to be acquired compulsorily. And that compulsory acquisition has now sometime overshadowed all other functions of the commission, but the commission has more functions than compulsory land acquisition. The other function of the commission in regard to rating, that if any objection is received, most of the time, as our colleague, the previous speaker, said, that it's not obvious for the role to go uncontested. Sometimes there is a contestation on the role, especially on the track rate applied, and when those things come, the commission will forward the same to the CS, and that thing will also be transmitted now to the tribunal, and it will be solved. The main function of the commission there is now to develop those regulations on how those mechanisms, to develop those mechanisms in the law, on how those objections will be handled at that particular level. The other thing on that is consider, I'm sure maybe it will not touch on you, because there are also some exemptions, even on public lands, the land, those lands that are supposed to be even included in the Valencia role. Our brother said that there are some property that are not supposed to be included in the road, or they are not supposed to be assessed for purposes of charging that particular levy. You know, all the public institutions are not supposed to be charged. All the health facilities, they are not supposed to be charged. They are not supposed to be levied, not charged. They are not supposed to be levied. Even forest, maybe a dam, and several of them that are not supposed to pay that the counties are not supposed to charge to levy the rate. So let's look at the way we listed. So those are some of the exemptions. Other exemptions are on some of the public lands. It has to be clear which public lands are supposed to be listed there and which public lands are not supposed to be listed there. There are also some lands that are supposed to be exempted from that particular levy. So in brief, that's also the commission will intervene at the end of the day, but more really on those mechanisms. And I'm sure those mechanisms that the commission will comment is what is missing in the act, the ADR aspect of it. You know, now it is very clear that there should be an alternative way of resolving this particular disputes in these rates. And I'm sure at that particular time, CARA will also be invited to be part of it, so that they can also propose the best way possible to be able to functionalize those mechanisms and to be able to propose the best way possible to handle those issues at that particular time. So I think mine was just brief because it was exhaustively handled. There's nothing else, and then there are specific questions to be addressed. Okay, thank you.
Thank you so much for being brief. I know there will be questions for the commission during the plenary, and maybe at that point you can be able to
make a comprehensive response. So we are coming towards the end of the presentations. I know we are all eager to engage our speakers during the plenary. So then I'll invite our last speaker, Mr. Herbert Were, who is from the ministry. He's the Director of Valuation in the State Department for Lands and Physical Planning. And this is the anchor ministry for this legislation. So I know they have a lot to do with the aspect of implementation and just overseeing how this is being rolled out. You've heard that the counties are supposed to develop their own county-specific law based on this. So I believe that there's something they're doing to support the counties that manner. But most importantly, just to tell us again what the ministry, the role of the ministry, and most importantly, how you are going to engage key stakeholders. And if there's going to be an opportunity to interact with this law further in terms of addressing some of the reforms that have been proposed so far, because even our members have been asking questions that areas are not happy about, and so we hope that we'll get that chance to be able to engage with the Act further and make those changes. So karibu Mr. Were.
Thank you, colleagues. Good morning. My name is Herbert Were. I'm from the Ministry of Lands, Public Works, Housing and Urban Development. That ministry has 3 state departments: the State Department for Public Works, the State Department for Lands and Physical Planning, and the State Department for Housing and Urban Development. So I'm here on behalf of the PS for the State Department for Lands and Physical Planning, Honorable General Nixon Korir, who couldn't make it due to exigencies of duty. And I'm here to represent him. The chair of the session has basically indicated that I shouldn't say anything. He has indirectly told me to myself. I just need to introduce my colleague, Jane Kairana. Jane, wave. We are from the same department, and because we believe in division of labor, we had agreed that I would make a presentation and Jane would answer all the questions. That is part of delegation. And anyway, maybe you'll allow me a couple of minutes just to understand the genesis of reviewing rating legislation within the country, because the 2 acts, the Rating Act and the Valuation for Rating Act, were fairly old. One was a 1954 Act, 1956 Act, and another one was 1964. And we had lots of changes in terms of constitutional architecture, in terms of local authority governance system, and there was need to align the rating legislation to the new constitutional architecture and the governance structure post-revolution. Further, a study was undertaken by the National Treasury on counties' own source revenue. This was informed by the enhancement of county government's own source revenue policy, which was published in 2018, and rating was identified as an area which had great potential for counties, but which was least exploited. The potential of rates was found to be underutilized compared to other revenue streams like parking, the revenue from the hospitals. So an issue arose as to what could be the issue that rates are not generating as much as they should. And the area of legislation was identified. So maybe I can just mention, why do we need this national rating legislation? It's because the previous framework had been overtaken by events. The previous acts were developed in a period where we had local authorities, municipalities, urban, town, who were deemed to be the rating authorities. And after 2010, we now had new rating authorities in the form of county government. So there was need to align that. And although Wakili Okello says ADR is not clearly spelled out, I'm not a lawyer, but from my rudimentary understanding, the County Valuation Board is an ADR mechanism, because it allows objections to be heard at that level before they are forwarded to a formal legal institution by the name of the National Rating Tribunal, and then thereafter to the courts of law. And this is a novel idea, so that there could be aspects that are not very difficult to handle, which can be resolved at that level before they are escalated further. Then the use of ICT tools. Because the way where we are going now, valuation, the tools of KAMA, it was important that the law provides that technology can be used in undertaking rating, as well as serving of notices, as well as communicating. Because the previous acts envisaged a situation where you would send letters by mail, you would serve people personally. But with this regime now, there is provision where you will interact with ratepayers in a digital the framework. I do not want to define rates, but maybe I could just mention that the Act has identified basically 3 forms of rating, where you could be using the site, you could be using the area, or you could be using the annual rental value. I think my colleague Okello delved into that, and because the chairman gave me notice, so you will allow me to move. So before pre-devolution, rating was governed by the 2 acts I mentioned, Cap 266 and 267. Then we had the Local Government Act, which is now repealed, particularly Section 216, which spoke to these aspects. But now, currently, post-devolution, the Constitution of Kenya speaks quite soundly about this. Before then, rates were deemed to be a revenue source that was not clearly delineated as a tax. But the 2010 Constitution, Article 209, clearly identifies property rates as a form of tax and not just any other ordinary revenue. And what is important for us to note is that the Constitution, while allowing local county governments to levy rates, we are also alive to the fact that Kenya remains a unitary state. Therefore, as a county develops legislation in relation to raising revenue, it must be alive to the fact that you cannot impede movement of goods, services, and labor across counties. And I normally give this example. If you go to Mombasa, the sand that is used for construction in Mombasa comes from Taita Taveta and Kilifi, because of the saline nature of the soils in Mombasa. So you can imagine a situation where the county government of Taita Taveta or Kilifi introduces punitive charges on lorries transporting sand from Kilifi to Mombasa. It will grind Mombasa to a halt. That cannot be the intention. The water that we consume in Nairobi comes from Nyandarua, Murang'a, and Kiambu, isn't it? So you can imagine if those counties were to introduce punitive charges on water or on the wayleaves that have to deliver water to Nairobi. So even as counties legislate, they must be alive to the fact that Kenya is one, and whatever legislation they develop should not run contrary to the national finance objectives of national government. So for us to understand rating, we may need to look at the other laws apart from the Constitution and the National Rating Act. We have aspects like Public Procurement and Asset Disposal Act, because if counties wish to use private valuers, the process of procuring those consultancy services comes into play. Because these are financial matters, they have to be alive to the Public Finance Management Act. And as you undertake the rating, you get access to people's personal data. How you handle it, we have the provisions of the Data Protection Act, because you can't be casual with personal data, because the penalties under the Data Protection Act are quite punitive. So there are a host of other laws, including the County Governments Act, because this is what is defining CECM, a chief officer. You will also have to look at the Urban Areas and Cities Act, because this is what defines how you set up a municipality, how you set up a city, what are the thresholds for an urban area, all those things. And they have a role, because when you are undertaking rating, considerations of planning come into place. Is it within a municipality? Is it within a town? Is it within a city? All these things come into play. Maybe just the salient highlights that have a bearing on our State Department is that the National Rating Act has assigned roles to the CS in charge of lands in preparation of certain regulations or statutory instruments. Of course, there are those assigned to NLC, and there are also those that are assigned to the county. Our thinking, if it will receive approval, is while developing regulations, whether it is NLC or the CECM or the CS, there may be need to do it in a joint manner to avoid a lot of friction, and also to ensure that this can be done, rolled out in a way that is harmonious. So that will depend on whether the other agencies will buy in, so that the development of these regulations can be undertaken jointly, so that you don't have a situation where NLC is developing regulations whose promulgation may be 6 months away. The minister is preparing regulations that may be operational 3 months away, yet these regulations have to speak to the same population, to the same actors, to the implementation of the same law. The other aspect is it has assigned the chief government valuer a role of developing standards and guidelines to ensure uniformity. This is not as a way of supervision, it is just a way of ensuring that rules prepared within the country follow a certain template that is accepted. And it is born out of a situation where we know rules that were prepared between 2001 and 2022, out of 100 valuation rules that were prepared, about just 3 met the threshold because of one gap or the other. So you can see local authorities spent money to prepare a valuation role, but that role could not be implemented because of one thing or the other. It will also minimize the litigation that has been evident when valuation roles are challenged and courts of law set them aside. It's just a way of ensuring value for money. It has also given him a role to be a repository of valuation roles that have been prepared countrywide. This is just for purposes of research, whether it's in the academia, and for purposes of records, so that there is an office that acts like a one-stop shop where if you have any issues about a valuation role undertaken in the country, you can be able to get it. Of course, the guiding principles that are in the Constitution, whether they relate to Article 10 or Article 232 or 175 on devolution, they have also been exported to this Act, which is very important, so that the law now is aligned to the Constitution. And I may make mention of the aspect of public participation. Article 10, sub-article 2A. When Kenyans gave themselves the 2010 Constitution, in as much as they have donated power to certain entities, they have that residual element where the governance structures must consult them when they are undertaking activities or programs that affect their livelihoods. And that is an area where CARA, because of your countrywide representation, you come in very critical, so that when counties begin to prepare roles, when they invite for views, when they are making notices, notifying people, we are applying this form of rating in this area, this form of rating in this other area, please take keen interest so that people can understand, because this is a taxation issue which requires their views to be onboarded. The rateable honor was explained. It has been largely expanded. For instance, the administrators, executors, executives, and it's for a simple reason. You and me know that we have cases filed under the Law of Succession Act, Cap 160, that take 40 years in court. I know largely many of them are from the political class who have a lot of wealth. So you can imagine a situation where a case is in court for 40 years, and because the rateable owner is the deceased, so who pays rates? So it was important to expand so that even in the absence of the rateable owner, the administrator, the executor, the trustee, whether it's a public trustee or any other trustee under Trustees Perpetual Succession Act, can be billed to settle those rates. Then it is very clear now on, in certain areas, like in the coast, you may have land, but the registered owner of that land is not known, can't be traced. But there are people on that land who receive rent, who receive profits. So this act now allows the county government to make those people, because they are the ones receiving profits and rent, so they can be able to identify where this rateable owner is, so they will be made to pay. The issue of registered agricultural freehold, it may, in my view, it may have a bit of confusion, because the definition of agricultural land, Okello, you may advise, it is not there. Agricultural land was defined under the Agriculture Act, Cap 318, which I think was repealed. So it becomes a gray area. Let us take, for instance, a place like Ruaka, or let's say Machakos, Katoloni, just near to Machakos University. Technically, the land abutting that area is agricultural, because the transfers are undertaken through the Land Control Act. You have to get a Land Control Board consent. But when you go to the ground, you find there apartments. The character has changed. So maybe it is one of the areas that may need to be looked at, so that we clarify when we say agricultural, what do we mean? Because I may have some quarter acre somewhere and in Nairobi, and I put there some 20 chicken and 15 rabbits. Can I validly claim that now is agricultural, isn't it? So they maybe need to clarify some of those aspects. Because my time is up, the public participation process, I think I've spoken to that. The term of evaluation role, previously it was 10 years with a provision for extension. Now it is 5 years. It is also an area I think may need to be relooked at. Anybody who has undertaken evaluation role, it is an expensive exercise. It is time consuming. The processes you go through before implementation, in my view, 5 years is short, but I think during the development of the bill, that's what the legislature settled on. But I know the 5 years with the provision for 2-year extension, that period will have major challenges with counties, considering the budget cycle and the election cycle. We are going to have an issue. So we've talked about evaluation role. So the supplemental evaluation role is just a role that is prepared midstream to amend an existing role, just to take into account properties that are omitted, properties that have been amalgamated or have been subdivided. So it's basically to amend exemptions. I think that process was covered. You will allow me to I don't want to talk about discounts and waivers or remissions. Allow me to make some mention on the enforcement. It has expanded the remedies that are available to the county governments in areas where you have perpetual defaulters, so they can levy a penalty. They can deny you certain county services. They can institute a suit. They can create a charge against your property so that it becomes an encumbrance on your title. They can apply any other method as will be authorized by law. They can appoint a receiver. They can take over management of property so that the rent paid is paid to the county until when the debt is fully recovered. But the last option is they can also auction the property to recover the rates. So it is also important just to mention that national government, like private citizens, also pays rates to county governments. And the payment they make is called contribution in lieu of rates. For private citizens, you are billed for each property. For national government, all the properties within a county are consolidated and you are billed as one single unit. That's why it's called a contribution in lieu of rates. And I may need to make a correction that government pays for land registered in its name, land that it is utilizing in the rural areas and it may not be registered in their name. It also pays for government forests. It makes contribution in lieu of rates. What is the role of CARA? CARA, you have critical role in sensitization of relevant stakeholders on all the aspects, including public participation, duties and responsibilities of rateable owners, as well as providing input during the development of regulations. So I invite CARA to be on the lookout when the process of developing regulations commences. Please make your voice be heard, undertake your research, and pollinate the process so that you can make it better. Thank you, because I can see the chairman of the session is looking at me with a bad eye. Thank you very much.
Asante sana Bwana Were. Thank you for giving those highlights, especially from the ministry. And also just finishing by trying to give some indication of the role we can play to make sure that we are supporting this process. We are certainly keen on the regulations when they'll be prepared, because we believe that it will give us an opportunity to clarify some of the gray areas that we have seen, some of the questions that have come forth, so that we can have a law that is actually addressing our needs and that is progressive. So ladies and gentlemen, I think we've heard enough from our speakers. I believe that so far some learning has taken place and some learning is going to take place, and of course now we want to interact with the learn from each other. So we are going to have some questions, and of course, in the interest of time, I'm going to request us to be as brief as we can so that we can take as many questions as possible and leave this place in a better place in terms of what you have learned. So maybe somebody can help with the microphone. Take the microphone round. So can I see those who have questions? Those who have questions? Things are not made. Let's start with this side. Just your name, maybe your association, organization, and straight to the question. Make it as precise as possible.
Good morning, Samu Diambo from National Residents Association. Questions which emerged was just at the close of the matter to Mr. Herbert Were. Yes, it was a short concern that we have seen issues of people saying agricultural land, and when agricultural land has been taken over, the issue of adverse possession. This is taken over by adverse possession from the government bodies. I don't know whether that is captured on this legal process, because what I was seeing is how the state or whatever recovers revenue or the tax money through processes. But now that issue of adverse possession has not come out very clearly. That is surrender of land. Please probably illustrate that.
Very much. Asante sana for that and for being brief. Here.
Good morning. I'm Silas Onjala, like Naivasha Riparian Association. I have a key concern on the aspect of valuation, especially the aspect of market value. There's the reality of land hoarding and speculative value of market on matters of willing buyer, willing seller. So the market value is always a moving target. How do we ensure we secure the public from having an exaggerated value of property? Thank you.
Asante sana. One of the speakers will respond to that. And as you ask your question, you can also be able to indicate who you want to answer the question as you go along. Let's proceed.
Good morning. Good morning.
We are coming.
Good morning.
Morning.
I have my voice kidogo. Excuse me. My name is Joseph Okeyo. I'm from Acacia Residence. I'm the chair. I have some 2-3 questions I wanted to ask the panel. Number one is about county government land and also National Land Commission land. I wanted to know, maybe for this, the purpose of this meeting, which lands are for National Commission, which lands are for county government land? Because there's been a lot of things which are coming out on that. Number two, I wanted to also ask about the issues of the parcel of land which are there. There is also the change of user. When it comes to rating, you find that I've just been told by Michael Okello that the rating depends exactly on the issues of the kind of land you're having, whether it's agricultural land, residential land. So when somebody has a residential land and is changing it to agricultural land, and the title was reading that it's supposed to be a residential property, how does the county government come in and be able to give a special rating for such kind of land in terms of change of user? Because now the user is now changing from that aspect. Number three, now when it comes to issues of rating, I could be able to say this, that if it's possible, the county government, which owns a lot of land in Nairobi, can be able to be giving us invoices in our phones, just like the way they're doing for the issues of water. They're giving us invoices on how much you're supposed to pay for water. Even if the water is not there, they still give you an invoice. If they can be able to also be able to automate the issues of rating, because it's difficult for you to go to City Hall to go and check on some of these parameters. You go there, you find there are no people. You go there, you find there's no information you want. So if it's possible that if they can automate these things so that you can be able to get it on your phone and pay, and just pay from your phone the way we pay our services like water and electricity, I think that will be very, very good. My last question here is, I'd like to say, is about the issues of, there's something which is also very, very important here, on the issue of public utility land. I stay in a place whereby most of the land have been grabbed. The public land has been grabbed by the people who are of power. So I'm asking this question that now, if this land is grabbed, and it was supposed to be public utility land, not possible for rating, now that it has been grabbed and now it has gone to the private developers, what scenario can it be able to be done that it can come back to the public land? Because there's nothing as bad as not having a market where you're supposed to be, and the market has been grabbed, schools have been grabbed, everything has been grabbed for the purposes of them to enrich themselves. I think it's important for the County Government or Land Commission to enforce some of these parameters, that if something is a public land, it should be a public land. Then this person who has taken this land, can you also tell us whether he's also going to pay rates? Because now there has not been any public participation on the same. Thank you very much.
Asante sana. Thank you very much. Let's finish with this row. Please, let's try and have one question per person at the back. Is that a question?
Thank you. My name is Anthony, National Housing Langata Residents Association. Just a quick one, Mr. Were, if you'd indulge me, I wanted to ask about the status of this act. It was assented in December. It was supposed to be implementation should have started in December 24. You're talking about regulations. Where does it leave this act?
Thank you. I hope we'll be able to answer that.
Thank you. Dr. Rose Wairumo.
Just speak up a bit, we can't hear you.
Rose Hinge from the Goto Residents Association. My question is, are freehold titles supposed to be rated?
Freehold titles. Okay. We'll get an answer.
I'm Victoria from Karen Langata District Association. And one of the questions I had was on public participation and the role of Kara. Maybe as a proposal, can we have residents involved even in the preparation and not when they have already worked on the regulations? Then it's more of a validation. And number two, on the responsibilities of property owners on the rates and the rating act. What I was thinking and what I was trying to see in acts, you have to have a duty and a responsibility and a right. What are the rights of the property owners when it comes to land rates, especially in relation to your county government? We know about the street lights, we know about the others. How do residents, as we pay the rates, how do we ensure that we experience the rights that are in the law?
Asante sana. Thank you. Let's move this side. We are progressing well. I think we are keeping to the rules of being very precise.
Good morning. My name is Timothy. I represent the Alliance of Kiambu Residents Associations. This is the whole of Kiambu Residents Welfare Associations. And I'm also the Secretary of Kahawa Sukari Residents Association. My question is directed to Mr. Okello. And it is a very specific question. We have a Kiambu County. Apparently, we are not sure, they did come up with a valuation role in 2014, which we are not sure about. But they say they have one. Now, in 2016, the County Assembly passed a law which introduced a new rating schedule. 2014. And the rating schedule was different rates for different areas. The county sat on that act, County Assembly Act. The county executive sat on it from 2016 until last year, 2024, and they decided to implement it. And unfortunately, there was no other question, no other participation, they just implemented straight away. It came out to be very primitive. Number one, there were some freehold titles which were subjected to rates, which was not happening before. There are some leasehold titles which were subjected to an increase of more than 1,000%. And this is the position where we are right now. The Kiabu residents associations are very concerned. In fact, they are at the point of going for litigation. But we would like to hear from Mr. Okello. What is the legal position of this particular action? And is that imposure of rate really valid? Asante sana.
Thank you for that, Bwana Timothy. My name is Angela. I'll speak with you some more because my question is related to his. Number one, will all these presentations be available to us, representing Gara, from Gara? So, Kiambu County does not avail that rule of valuation. Is it available to NLC, to the ministry, so that we can see it and interrogate, because it is shocking? That's our experience as he has described it. But they do not give us access to that valuation role. So does the new Rating Act allow for access? And when the county fails to provide that access, can we come to national government, the ministry, can we come to NLC and access the same? Are they obliged to submit that valuation role with yourselves? Is a question that I have. And then I have one more, and it's related to my colleague there who asked. The Act is very prescriptive on the consequences of not paying rates. Concomitantly, is it prescriptive? Because I didn't see for absence of services. We pay rates, we don't get the services. What happens to those counties? Can we be shown what section of that Act that prescribes the consequences for those who pay rates but don't get the services? Because if they can attach and do all manner of things that you've prescribed there, what is available to us? So I hope I've made that very clear. Angela, Gara, G-A-R-R-A. Yeah.
Thank you so much. I'm Abondo Evans from Pamoja Trust. Mine is quick. First, I don't understand why we are in the same country, but someone in Mombasa and the other in Turkana have their lands valued differently. It's awkward because devolution was not supposed to bring confusion, but to state in this country. Then second, what is the place of community land? We've talked of the public lands and private ones, but what is the place of community lands? We know communities are now registering the lands in terms under the Community Land Act. So what is the place? Are they subject to the rates? Thank you.
Asante sana. I think we are done with this. The last row.
Good morning, everyone. My name is Kennedy Oludo. I'm also a valuer with the National Land Commission. So I've got 4 questions that can be answered by any of them. The first one, I would want the panelists to help the organization understand whether land rates are payable on leasehold and freehold. The second one is about the difference that there is between the annual rent and land rates. They'll help us understand. And then the third one is about the technology. The Act talks about the technology that would be employed when it comes to rating. This is directed to our Director of Evaluations. Kindly elucidate on that. What kind of options in technology that we would have in preparation of the evaluation for rating. And then the last one is about the National Land Commission. Do we have a say when it comes to private land? Thank you.
Interesting, because I was also from the commission. So maybe you'll end up answering those questions. Thank you very much.
My name is Rod Evans from Autonomous Association, and I agree with everything that has actually been said. There is confusion, Sam, in the whole sort of business. You say there is coordination, there's no coordination, everybody's doing their own thing. And who are we targeting at the moment? I think that we've got maybe 4%. If the counties really wanted to sort this roll out, go out, get your roll done. Now you don't need to raise anything more other than collect the rates from the people who should be paid. That is the problem. that we're getting a whole small community that is actually paying and a large community that is not paying to date. And in which case, if we collected those rates, then we would be fine on that. We've mentioned the freehold, but I think my biggest problem is also technology. Adisasa, you try and get on that, they tell you it's a Kilifi County, go onto Adisasa, it'll tell you what you actually owe. You can't even get onto the thing. You spend hours on it. Eventually we've gone back to the county and forget about the technology. Where is the technology? It keeps collapsing. Thank you very much.
Okay, thank you very much, Mr. Chairman. My name is Jenga Kamoyo. I come from the kitchen garden of Nairobi. That's the Dagoretti area. And actually we are really confused about the whole issue. And especially my area, which happens to be in the city, and yet, when having been caved from Kiambu, we have free title deeds. And as one question has been asked about free title deeds, are they rateable? And if the question happens to be yes, at what point do they become rateable? I'm just expanding the question from one lady there, who just asked a flat question. So, and if they are not at all rateable, why are some reviewed by the Nairobi County government? Then there was an explanation, a good explanation about, I'm forgetting his name, Mr. Okello. The difference between tax and rate. But according to the explanation which has been given, it is as if now the rates are becoming a tax. Just like the affordable housing, the way it started, it was voluntary and then it became a tax and applied on the payslip. Is this the same way we are heading? And my last comment, actually, which was given by Mr. Were, you did mention about if somebody is defaulting on the payment of the rates, that several methods can be applied. And the last one which you mentioned is that the property can be auctioned to recover this. Is the government not contradicting itself about the settlement of its citizens, yet if you now auction the property of somebody who is already settled, you're making him to become landless? Thank you.
Asante. Thank you, ladies and gentlemen. My questions are very few, but I'm going just to, most of the questions that I could have asked, they have been asked, so I cannot repeat them, but I wanted just to give more of a request from our panels. We, as residents, I'm from Landimawe Residents Association, and also I'm from a place called Sigoma Welfare Association, that is in Siaya County. I want just to highlight, there was a project called Lower Nzoia Irrigation Scheme, and I've come to realize whatever you're talking about has touched that area, whereby the aspect of public participation, we have come to realize most of the state officers, they don't realize what is public participation. They think public participation is a matter of calling the people and giving them half a bread and a coke. Public participation has its own procedure, and it has to be defined. In that public participation, who said what and what was the resolution? What about the dispute resolution committee? What are their recommendations? Those are the kind of things. The professions have said what? But you have come to realize most of the government officers, especially National Land Commission, have come here just purposely to talk to your chairman. We wrote so many letters on complaint and you don't even respond. And that's why I concur with him for failure to come to such meetings, because he knows what he does in that office. Two, you have talked about CARA. You have talked about CARA. To come up with mobilization to sensitize the residents in the aspect of public participation and give view. But we don't see you people also assisting CARA so that they can mobilize the people, so that they can have logistics to move around, across the country. Because CARA depends on the revenue collected from the residents. And there are some residents cannot afford even to pay those renew subscriptions. So you have to understand with the aspect of the country where the economical situation, we are in economical limbo, people have been retrenched, people are suffering, the economical whatever. So we need also the government. And that's why we need PS to be here. We need the CS to be here. Why when they are called in parliament, they go. But when they are called into the community to see the people, the real people, they don't come. Are you getting it? So we are kindly requesting such kind of meetings. Let your senior guys come. Let's say like CS, PS to come and receive information direct from the community. That is how we can go as a community. Again, mine when I reflect on what is happening in Lower Zoya, the valuation aspect, especially National Land Commission, and also there's a problem between the county government and land ministry. When you have a problem in land ministry, they'll confuse you to go to county government. And the county government also have valuers. But it is not their role in that line pertaining to the issue of national development. They'll say that that is an issue of national government, so it is upon you to go to Ministry of Land in that particular county. So kindly, may the state officers attend to us. May the state officers also assist organizations like CARA to play its role to assist that common mwananchi who cannot afford to ask a question or to give a view. Most of the community, when you go to the community, you don't want even the professions. Let the community have their own valuers, their own lawyers, so that to assist them in these matters. Because you come and you go to a layman who does not know anything, and then you just write a list and take the ID number and say they had participated. I have an issue with the Lower Nzoia in Sigoma area. Even they have gone as far as destroying even the land, the demarcation of the land, without even the consent of the owners. You are being threatened that that is a government thing. If you do stop it, you will pay the cost of delay. So what is that? Thank you, ladies.
Thank you. Thank you so much for that. One last hot one. I'm told there's one here.
Yeah, Ezekiel Langweni from KLDA jurisdiction. Now, there was a committee of Undungu some years back which did a very good job, and there were recommendations. Is there any way out that this Ndungu report is going to be recommended? And more specifically, I talk of some areas some plots which were grabbed by the famous grabbers in this country, and they were supposed to be for public utilization. There are specifically 3 plots in Karen of 5 acres each which were grabbed. Now, how can the local association reclaim this for public utility? Because that is a question. And a comment to Kara, please, we need to look for a way how we can compel all residents to be members of the associations. Then we can be able to move forward. Thank you.
Thank you so much for those comments. I know there are people who are also following online, so my team, maybe you can check if there are questions online that we can bring to the fore. Then speakers will be able to respond to them. But there are a number of questions that have been asked, very pertinent question, and I'm sure our panelists have listened, they've taken note. So we are going to have a response in the manner in which we had the presentation, starting with Mr. Okello. A number of questions are directed to you. I've noted them down, so if you skip any, I'll remind you, because I saw you also noting them down. And then we'll go to NLC and then the ministry in that order. So Banokelo, karibu.
Thank you, sir. And thank you for the feedback. When questions are raised, it actually implies here that the team is keen. Let me start by addressing the disputes and conflicts that arise involving the rateable owners and the rating authority. And that is why, as Mr. Were said it correctly, the county valuation boards are a good appendage to what would have been the tribunals and the courts. The Constitution under Article 159(2), it provides for the alternative dispute resolution mechanisms, including mediation, negotiations, and traditional methods. My comment is this, especially in areas where we foresee conflicts will arise. This is my suggestion, and I said, it is not clearly stating the approaches in resolution of the disputes within these boards. And that one is very critical. The best reference you can make is the Intergovernment Relations Act. If you check that act properly, it actually outlines the processes of resolution of disputes involving the counties and their offices. And I'm advising for the residents, because you are representing the entire area across the country, when the stipulations of the regulations will come forth, insist that the methods and the step-by-step processes of resolution is put in writing, so that there's no ambiguity in the processes. So that, as somebody said, if disputes were to be resolved, you don't know what was made and you don't know what processes were followed. There should be documentation in the adjudication processes involving rating process, how the valuation issues were raised, and they were handled properly, and where contexts are. The operations and proceedings of the board should be clear in writing. The operations and the proceedings of the tribunal should be clear in writing. That one will come in the regulations. So insist on that when the participation will come. Another question that I've picked.
Most likely they put a law, and now you ask yourself, is it a lower percentage of rental value per annum, or market value, or an improved site value? So then you gauge them. But you can always do comparative
analysis. Nairobi, Kiambu, Mombasa, Nakuru, Eldoret, Kisumu City. How do they range? So that actually you will note whether there is an overly, exponential increase up to 1,000% I had. And the place you can fix this is in public participation. Remember, at public participation, the roll has not been published. It is the fresh draft. The chief government value also has his copy, and he will give his report. If he finds that these people have actually over-exaggerated the indices, maybe for area rates, Mr. Were, actually the director will tell them. And that is why his report is required. We are in the better place than we've ever been. And that is what I'll say as I end. Thank you.
It's still morning. Good morning again. There's some questions that were directed to the team that is sitting in front. I will answer the one that touches to a commission, and maybe leave the rest to a director, because they have the rating department here. I'm sure they will guide us properly. On the issue of the market value, I'm sure Okello said something on the market value. Market value is something that we have always been hit hard as the commission. In this case, we are being accused of undervaluing it. But here now, we are being told that we have overvaluing. Values varies. Any market has different values. But when we go to the field, there are always parameters that valuers have to put in place to make sure that you get the current market value or an indication of the market value. We go there, we are required by law to collect current data on land transactions. And the first place that we go is to any ministry, any registry in the region. And what we are supposed to collect is something called a stamp duty declaration. A stamp duty declaration says the amount of stamp duty paid upon transfer. That one will give you an indication of the market value. As you have a particular investigation to its conclusion. So if anything is received by the commission, they have a department free for that to to investigate that particular allegations and to come to a conclusion. So in case there is something, even in the Ndungu report that was not even concluded, it's upon now the association to write to the commission, and the commission will give you a hearing. Thank you. On the issue of the regulations, I'm sure the act is still new, and the regulations maybe have not started or they have started, but our urge is we should all be part of it. Our director from the ministry said that we should have a consultative forum, that the ministry, what they are making, the commission should know, and the council of governors should know. And in this case, actually also the association must know what is going on, so that we don't have a duplication of recommendations, or we don't overlook on some of the aspects. So I think we should just look for a platform on how to invite everybody. So at that particular point when we are making these rules, regulations, everybody should be part of it. Rose said about the freehold land. Under this act now, under section 28, it says that all land are rentable. All land are rentable. So it's now upon your interpretation to seek further clarification. What does it mean? Because it means either it's a leasehold land or a freehold land, but all land are rentable. I think we can debate on that. Anything else on the commission? That's what I'm saying, is open for discussion now. It's purely open for discussion, because the act says that is any land is rentable. Before this particular act, I think the other one used to say that a county or a council can declare an area to be a rentable area. But now this one says that all land is now rentable. I'm sure from the ministry you will get clear definition and interpretation of that particular. Yes. Mm-hmm. Yeah. Madam has taken care of it, and I'm sure she will provide. A clear answer to it. Anything else that I'm supposed to take? Technology is still a challenge, but we're working on it. Yes, I'm sure Adisasa is testing that particular aspect of the technology, and I'm sure this one also must be, all those other things be automated for easier, even offering services and even collecting of these particular things. So I'm sure it's something that must be worked on, because so far we are still lagging behind, but it's something that must be improved. The law says that, the previous law that says that a valuation rule is valid for 10 years. And there could be supplementary rules. This one now, the act says that the rule is within 5 years, with 2 years for supplementary. So if our role has extended to 7 years, I don't know, Madam would say, what are the solutions? Is it for the new rule to be prepared? If the time has elapsed, for example, they say in Kiambu there is a role that was prepared in 2014. It's 2014 plus 10, 2024, and it was only last year that they have started to implement that particular, and the time has elapsed. So I don't know the definition of it, but they are supposed to prepare a role. Even this one now, they are saying any county that has not prepared a role, they are supposed to prepare a new thing as per the new act. So I'm sure maybe they will also either rationalize that one or prepare a new one as per the new act now. I'm sure because a discussion will also go on there. On the issue of provision of services, I'm sure our colleague, the speaker that spoke, that you pay and these services are provided. Community land. Community community land that is registered, and there's community land that's not registered. For that one that's not registered, there is no issue. There is no issue for now. If it is not, because it's not known. But a community land that is registered, I have no idea whether it is taxable. I have no idea. I'm sure Madam will tackle that one. We will tackle that one. Whether it is also false, and now at section 28, that all land are ratable. And this is a community land. We will also try to unlock whether that community land also that has a title deed is now supposed to be subjected to that particular rate. Our colleague had asked about technology. Technology, I'm sure, is something that must be done, something that must be updated so that all the services have been automated. So even for notification purposes and even for easier payment. On the issue of the private land, I think I did not understand his question on that one, but I will give him a chance, because as part of the commission, to also try to assist the organization to further understand, because I'm sure the reasoning of asking for that question is just for all of us to be able to have knowledge on it. He will also have that one and elaborate further. The issue of county land and national county land. One commission does not have land. What we do is we are managers of all the public lands. So we don't own land per se, but we manage on behalf of the national government, we manage on behalf of the county government. What that is, county, we assist county also to regularize their lands. If they want to issue title deeds, from allotment they want to transit to a document that is recognizable by law, they always write to the commission. And then commission will regularize. After that, allotment will be given. After the allotment, it transits to the Ministry of Lands for a list to be issued. So in my understanding is we don't have land. We are just a conveyor belt. It comes from the county government, we regularize, it goes to the ministry, and documentations are issued. I'm sure penalties and auctions and remissions have been well tackled. If I come to the issue of Zoya, from a member here, I don't know what association, the commission always carries public participation for any project. And public participation it has several aspects. One is to pass information to any person affected by that particular project, and he lives in that particular area or has an interest in that particular area. You have to be educated that there is a project that is coming. How do you educate? By circulating first the gazette notices that has published those lands. You may not be affected by the fact that you don't have a land there, but maybe directly or indirectly you are affected. So we want to hold meetings and circulate those particular notices, gazette notices, and have public balances. We even start by going to the office of the governor in the host county. We go to the county commissioners in the host county, even to the chief, all the way to the chief levels, just trying to pass information. We might not have maybe solutions immediately, but the fact that you have the information, at that particular point, you are now informed. You are now informed. And in some instances, actually, we are even influenced for the formation of dispute resolutions committees. We can go, we always go here, and people are clueless. And we always recommend to the acquiring body that there should be maybe even a committee, that there is a chair, there is a members who always represent the affected people generally. And in most of the cases, we are able to solve those issues, we are able to pass information, and we are even able to acquire land and even pay to some extent, not all of them. The issue of our business being here, and I'm sure it's also beyond us, we can dictate our CSS to our CSS to be here. I'm sure now it's incumbent to you now to make sure that you reach to all those offices and emphasize on the importance of them being part of these particular meetings. You know, as we are just enjoying delegated powers, we can't dictate to them. We just messenger or we don't even qualify to call representative, because those are high-ranking officials, those are public officials, and they have tight schedules, and you know, the situation that we are currently. I think in short I'll be able to answer those ones. I will pass now the mic to our director. Okay, in case of anything, I'm sure. Yes.
There was no reply from the Ministry of Land, from the Ministry of Water, from your office. No reply at all. And it's not even one letter. There are more than 10 letters and I have evidence of the same. I get it. So when you are coming here, my friend, you know very well we are the community and we are the affected people. And do as per your lecturing us. But when we don't get reports from your offices, and this is the time you need to be to your bosses and tell you, this is a letter addressed to you. Received on such a date and no reply, and the process is gone. I'm affected, even my land with a dispute, they end up passing that canal without my knowledge. The day they were doing that construction work is the day they called me, telling me that the canal now is passing. The matter will be handled later, but they don't do pay. Yet later on they pay. I get it. The valuations are done in the office here, in the land office. Before you move, land office, room 340 to 315 there, third floor. And I'm telling you, my friend, when you see us talking, we are talking in evidence, we are talking full reports from CIA, the collaboration of state corrupt officials who are doing these evil things to the community is so painful. By virtue that somebody cannot travel from Kisumu, from here to here, come and raise complaint the way you are misconducting things. Mr. Agut, the chairman of LLC, chair, when I raised this matter, he told me that they are going to call me on public participation on the initial stages. But when the time of public participation, when the time of meeting comes, they call me at 4 p.m. for a meeting of tomorrow at 9 a.m. I get it. That route was taken to Turkana. There's another one who was brought in, looted everything, and then he resigned and fined. So let me sure, your office needs to be clean. Thank you.
I heard you, and I cannot ascertain that what you're saying is true. But at least you know our offices, you know where the chairman office is, you know at least you get clear of exactly that avenue in case anything personal, that you have to bring out. Even the access, there are clear ways on how to solve these things. First, you handle the person who is handling the project. Secondly, if that's not working, because there's no way that you can be paid without accepting. You can say that I was paid without knowing, because the law says once you are given an award, you are supposed to either to accept or to reject. Once you reject, the law says that now you go to environment, land and environment court so that you can be heard. Even now it's easier because you are told you are supposed to go to the tribunal. Now we have a tribunal. You first to go to the tribunal and then you will be given a hearing. But if the tribunal is not able to solve your issues, again there is land and environment court that will give all of us a hearing. So now the law is very clear. So in case you are paid without accepting, you know, I don't know. Anyway, yours will be addressed. Yours will be addressed. I will give our director also to say something. Yeah. Okay, thank you.
Tabu, please, let's have some order.
I think you made your point, yes. And we can take it up on one basis. We made a point up, so take them and direct you.
Bahari imechafuka. I'll attempt a few, and then my colleague Jane Kairana will look at them. There's Odhiambo Sam, he mentioned something about adverse possession. It wasn't very clear to me, but the law that governs adverse possession is the Law of Limitations Act, Cap 22. And for you to claim adverse possession, you must have lived on that land for 12 uninterrupted years. So if you live for 11 years and 11 months, and the landowner serves you a quit notice, time begins to run afresh. Number 2, you must not have any relationship with the landowner, either as a beneficiary of some sort, an employee, nothing contractual, or a lessee. So you can't make a claim. And number 3, you must have entered the land peacefully. If you get to the land violently, adverse possession cannot protect you. But for you to realize adverse possession, you file a suit in the ELC court. The court listens to it, and if it finds merit, then it will award you land. But we have also to be careful, because this is an area of the law that can be abused by goons to disinherit people and disenfranchise people. Silas, was it Wanjala from Naivasha Riparian? You raised something about speculative market. If there was a felt pen, I would draw a graph there and show you when we say market what we mean. When we say market value, we are drawing a line in statistics. You can call it line of best fit. You will have somebody who has a patient to take to India for emergency treatment. That person cannot wait for months marketing his property. So if his land is worth 20 million, he may take 12 million so that he gets the patient to India. You will not use that as a market. You will have another person who is the proprietor of a neighboring parcel of land and is fearful that if he lets this land go and it is sold to somebody else, he may put up chano dens next to his residence. So this person, while the land is worth 20 million, he may buy it for 30 million because he just must buy to protect the value of his property. The valuer will not look at that as market. The Indian one will not be market. The valuer will look at the line that is plotted, which is best fit. So I think we will need to get that. And because I'm from the State Department of Lands, I can tell you that when it comes to paying taxes, stamp duty for instance, Kenyans will invariably underdeclare. We are never passionate about paying taxes. But when it comes to compulsory acquisition, so we must make up our mind. The same person who declared that he bought land at 10 million, the transfer is there, the requisition is in the office. When you want a project to go through, that person emerges with a transfer of 25 million. Okay, you are a lawyer. There's this thing they say, you cannot go before equity with stained hands. You must come with clean. So, unajua hii ni panga inakata mbele na, so make up your mind. Leo ni inakata ikienda hivi. Itakaporudi, huenda ikakukata. Then the issue, Joseph Okello automation, I think that has been dealt with. Anthony, you raised the issue of the status of the Act. It has been clarified, assented to on 4th, implementation day 24th. But under the Interpretation and General Provisions Act, regulations will continue to operate until when you have new regulations. The only difference is if there is something that those regulations patently depart from the provisions of the Act, then the interpretation of the Act must be aligned to the new Act. But until that time, when regulations have been developed, we will continue to use the regulations of the previous Acts, but read them, implement them with this Act in mind. So as it is now, this Act is operational. And you see it is regulations that breathe life into a statute, because The statute will provide the general guide, but then the regulations will give specifics on struck goes through the Finance Act, which is an annual act, or ground rent, or sometimes it's called land rent. This is a tax that is paid to the lessor of land. For instance, if government allocates you land for 99 years, the letter of allotment will indicate the land rent that you have to pay every year. It is payable from first. That one will be paid to the agency that allocated you land. The land, if it's next to the NLC, if it is county government, that land rent is paid to the county. So there are certain places which used to be called trust land areas, where the county will be collecting two taxes from you: land rent as well as rates. In other places, you will only pay rates to the county and land rent to national government. Technology, it's been cleared. Then I think I've mentioned rates track. The issue of digitization with RDSASA, digitization is a very expensive venture. That's why it has taken time. Nairobi, within the State Department, Nairobi is largely digitized. It's almost 100%. Of course, you always have new documents, so you can't say 100%. Murang'a has also been digitized. Digitization is now at advanced stages in Isiolo, Marsabit, and Mombasa. We actually have teams who are doing a lot of capture. Our desire is that finally, when we are done with the digitization, we will not need people to visit our offices. You will be able to transact, submit your transfers online. You will be able to query any deals online. You will be able to, whatever activity within, you will not need to come to our offices. And then ultimately, because it's a national land information management system, it will be linked to other agencies, so that even counties, they can also have a module where you can also query and see what are your rates, how much is land rent, and it will be interconnected in a way that if you are querying something on somebody's land, that person receives a message just to confirm that he has authorized you to, because we also have crooks, isn't it? People who want to find out who owns what so that they can manufacture parallel documentation. But this is work in progress. It will take a bit of time. Freehold land in Dagoretti from Jenga, well, if it is not agricultural, you will have to pay, clarify. But what we normally advise is, please give sufficient notice for public participation. Don't invite people today and the session is tomorrow. As a bare minimum, give people at least 14 days, 21 if possible. Then number two, let us have a record of people who attended with a unique identifier. The only unique identifier is an ID or a passport. And to make it better, get the contacts of those people, so that when an issue arises, you even have their mobile or email numbers. Number three, keep a record of the minutes of public participation. Please do participation. You have 400,000 people in 400,000 different views. So you use that best fit, that line we were talking. So you use that best fit, that line we were talking about. What is reasonable? What is a bit like an outlier? And recovery. Let me give my colleague nafasi kidogo msikie sauti yake pia.
Good afternoon. I'll just briefly, because all the questions have been answered, I'll just answer some of the questions.
Number one, the NLC are not rateable. They are rateable. If you look at the leasehold that is put in the Act, it says anything registered above 25 years. And the reason why it was considered, it's because sometimes you find a place like petrol service station, which has a list that is registered. It has been listed by somebody, and maybe a canoe. But in the valuation where you might not find the canoe, you will find maybe Total petrol station or Shell petrol station. But it doesn't mean it's the owner, but it is the rateable owner at that time because it's a registered lease. Then the issue of definition of market value. If you look at the Act very closely, the definition of market value, it's very clear. It says an incumbent freehold interest. That's what should be rated. So you cannot say because your lease is expired that you are not going to pay rates. Actually, we took care of that so that it can take care of the leases that are expired. Because people will come and say, my lease is expired, yet you are expecting me to pay rates. So it does not depend on that. You have to pay the rates. Then the other issue I wanted to comment about, the issue of Kiambu, of the 2014 valuation rule. Actually, this valuation rule was prepared by the ministry, the national government. It was for 2014, but it was taken a long period. And as my colleague said, that it takes 10 years to expiry under the old Act. So it means by 2024, your valuation rule is expired. Not to be charged any rates on that. So the assembly prepared a different rate structure, which was implemented immediately. It means this valuation rule, as far as we know, the information we have, it was implemented during the first government, then it was shelved, and maybe now it is coming up. It doesn't mean that it is not legal. It was legal last year when it was introduced, but from this year, I cannot vouch for it because time is already not on their side. It is already expired. And the other issue is that before, freehold were rateable according to Cap 266. When we read Section 6, it was Section 6. The freehold land was rateable. That's why even in this Act, Mr. Wara has explained to you that all the land...
It means it was rateable in the first place. It means it was rateable in the first place, isn't it? And Nakuru County, Nyahururu County, and Kiambu County, they border. So what is rateable for Naivasha, what is rateable for Nakuru in areas around Naivasha is jurisdictional. And then we say, within our jurisdiction, all this land is rateable. Which one do we exempt? So for you to exempt, first it must be liable to be paid. So let's get it clear. So when we say rateable owner, so this one means a person in whose name a particular property is registered and includes any person specified under. Mr. Were read it. But now, rateable property, within that rateable area, Section 20.
So we'll share the presentation. You can be able to engage the panelists one-on-one during this during tea, so that you can be able to get clarification that you may want to have. And of course, you're free to also take their contacts, and you can follow up with them, information from them. As we come to a close of this session, just to remind you again what my chairman said at the beginning of the meeting, that as CARA planning our annual general meeting end of this month, specifically on 28th of March, to come on board. For those who are still not members, come on as members, and not members, come on as members. And for purpose of AGM, if you are yet to renew your subscription, please do that, because by law, you're supposed to do that before the AGM, so that if there is need to make decisions through voting, then you can only do that if you are up to date with your subscription.
So it's important that you take that into consideration. Again, we have very, very good institutions here, and somebody talked about public participation and the need to make sure that this is done, public participation, and the need to make sure that this is done across board.